So welcome everyone, both here in the room and also we have an audience joining us online via live stream. I'm Catherine Wilhelm, Executive Director of the U.S. Asian Law Institute at NYU Law School. And our speaker this morning is Hualing Fu, who is Dean of Law at the University of Hong Kong. And this semester, he is the Jerome A. Cohen Visiting Professor of Law. We're thrilled to have Dean Fu with us. He's widely known and respected among scholars of Chinese law, both inside China and beyond. He's known for his prolific writings on a wide range of topics in comparative law and in Chinese public law, including criminal justice, the function of judges, mediation, rural legal services, anti-corruption, and authoritarian legality. One subject that he frequently returns to is legal rights and how they are or are not being protected by lawyers in China. So this brings me to the topic we're going to discuss today, which is pro bono as political control, public legal services in China. Dean Fu is going to share some research that he is currently working on about an ongoing process he has noted that is reorganizing the legal profession to some extent. On one hand, it is dramatically expanding public access to legal services, including representation in court. And on the other hand, it may be expanding official control over lawyers. So our program will be organized this way. First, Dean Fu will share a summary of his research and key arguments. And then I will exercise moderator's privilege and start the questioning. And then I will open the conversation to you in the room and also questions from online. So,
thank you, Kathy, for the introduction. Thank you for coming this morning to listen to what I have to say. So, pro bono has been primarily conceptualized as a payback to society by a privileged profession. Occasionally, it is characterized as a commitment of lawyers to public interest. Using the Chinese case as example, I argue that pro bono work can serve as a tool of political control in specific context. By control, I mean the ability of government to frame a dispute and to determine the course and the direction of legal action. My principal argument in this paper is that disputes can be seen as property, and that their ownership has been at the heart of the contention over the control of lawyers in China in the past few decades. Disputes can be used and abused for political objectives, depending on how they are framed. For the government, social forces led by lawyers, some of them can exploit social conflicts using legal services as the entry point to challenge the state, both legally and politically. When that happens, the state seeks to reassert its authority by reclaiming ownership of disputes and the power to frame them or reframe them. Contentious examples in the past many years, China include, right? Legal aid can either be framed as a provision of welfare measures provided by benevolent and paternalistic government, or an opportunity to claim one's rights against arbitrary power. Domestic violence should be prohibited because the prohibition can prevent further escalation of violence, so the battered woman syndrome does not develop, and the women do not kill their abused husbands, or as a legal empowerment of abused women to assert their rights. The third example is labor disputes can be framed as a mere violation of a contract term, or a failure of workers to organize themselves, bargain collectively, and take industrial action. A final example would be a religious persecution can be framed as a lack of mishandling evidence on the part of the police, the prosecution, or a violation of a constitutional rights of religious freedom, right? So as you can say, framing is consequential and lawyers can be potentially very important in framing disputes and conflicts. So before I proceed further, let me just introduce legal aid in China. There's no equivalent to pro bono in Chinese. I presume in Chinese, in English either. So the term is often used in Chinese context is either legal services, volunteers, and legal aid. In this paper, I use legal aid to capture what I'm trying to convey. Chinese law guarantees free legal services for the poor and special groups of people such as the victim of domestic violence, Samaritans, Samaritans in several disputes, or families of heroes, revolutionary martyrs in defamation cases. In policies, the scope of coverage is broader. For example, China claims to provide legal aid for all criminal suspects and defendants who cannot afford a lawyer. So the Chinese law imposes double duties: a duty on lawyers to provide legal aid services when appointed, and on the government to supply a standing budget for legal aid. So the Bureau of Justice in China, the professional government regulator is duty bound to appoint legal aid lawyers and pay them for the service directly. Very similar to the legal aid systems in Germany, in Poland, and other European countries. So it's a combination of lawyers' professional responsibility to serve and the government's duty to pay. So in that sense, lawyers in China are quite essential actors in the legal development, and the government is quite determined to bring the profession under control in multiple ways. This paper makes that particular argument. So by 2015, the party and government became very suspicious of lawyers and other civil society actors. For the party, putting it in an extreme way, enemy force was emerging in the legal profession. So I paraphrase one editorial from People's Daily. The lawyers thought to subvert the socialist system, relying on foreign support, weaponizing people's grievances, and using the system to change system. So in response, the party resorted to criminal prosecution, professional discipline for leading activist lawyers, effectively removing them from the legal profession through criminal punishment and the professional discipline. It also created the party cells in our law firms, requested partners to join the party, and recruited party members among lawyers from roughly 35% to sort of almost 50%. It has put the legal profession on notice. But at the same time, as the repressive movement and the reorientation of the profession was taking place, the party government did something, in my view, is quite extraordinary. That is the procurement of legal services from lawyers and the creation of a public legal service platform, right, with quite innovative designs to bring lawyers on board and become more state adjacent, which has been a term commonly used by research. So, of course, government spending on legal aid is a good thing. At a time when most of government globally are reducing their contribution to legal aid, China probably is a shining example of providing legal assistance to the poor and the vulnerable. But the key point here is the expansion of legal aid allows the government to reclaim ownership of disputes and enhance government control over the disputing process through embedding lawyers in the state system. So since I'm the Jerry Curran professor here, I I will have to tell stories. So to speak. So I tell three stories. The first is the sort of a political story. Second is the economic story. The third is a sort of a professional story to illustrate or to highlight what the message I'm trying to convey. Right. So first, a political story. Few laws in China, in my view, are as politically significant as the lawyer's law of 1996, which delinked the profession from the state, forming at least theoretically a proper legal profession with its own identity, financial autonomy, and freedom in practice. By socializing the profession, the party gives away direct control over a potentially powerful institution. I can only think of that one particular institution that party has sort of gave away direct control. So the socialization transformed lawyer from state workers, as it was used to be called, working for paid by and accountable to government, to a profession, as the lawyer's law said, right, responsible for the interest of their clients. Right? So when the lawyers emerged in 1996 in the legal market as sort of a free professionals, they were embraced by what I would call a decade of rights of the 1990s. In the sense that most of the legal rights in the statute books in China were created in that decade, right? Including the rights of disabled, the consumer, women and children, worker, criminal suspects, and of course lawyers, accumulating in the signing of SACPR and the ratification of the Covenant on Economic, Social, and Cultural Rights. So under that unique political circumstances, the lawyer and their friends, supporters began to put some of the constitutional rhetoric into practice, aiming for some structural changes through law and legal action, modeling principally on the American experiences of public interest litigation, impact cases, social legal movement, lawyers, NGOs, and social medias form what I call rights conflicts, working with NGOs to reach out to the communities, using litigations as a legitimate entry point to the legal system and public sphere, relying on social media to mobilize broad social and political support, and organizing online, offline activities parallel to the legal process. And of course, often with the backing of overseas funding sources. They aimed at a broad policy and legislative change, and more significantly, some structural and transformative changes. The agenda is to change the system through individual legal cases and change the system through the system, as it was called. So alarmed by the real or imagined political challenges in the context of a global color revolution, allegedly aimed at a regime change, the party pushed back systematically and very forcefully, ideologically and institutionally. That is well documented by researchers as Eva Pels and many others. So I'm not going to say too much about that point. One point I want to sort of reiterate, highlight is, well, the party may have tend more authoritarian and repressive in many aspects, in taking certain spheres out of the law, subject them to its own prerogative powers. It has also addressed grievances and disputes in the remaining spheres through legal mechanism. So the party seems to have come to the clear understanding that for ordinary social and economic matters, a legal process is the best process, preferable to the police coercive power. A legal system cannot function, of course, properly without the assistance of an effective legal profession, of course, guided by state objectives. but lawyers need to be nudged to play a constructive role in the new era. Right, need to speed up. So the economic story is a simple one. What's the solution? Well, solution is the government procurement of legal services. It was initiated in the 2000s, but gained momentum under Xi's leadership. The aim is to introduce the market elements to the social services. Government spending on procurement is very substantial. I think it reached 100 billion in 2022. Of course, the legal service is only a small part of it. So what are those public legal services? I just gave you a few examples. One is what is called the 3+X, right? The government will build platform, physical or virtual. The 3 will include legal aid, mediation, legal advising. X will be something lawyers can do according to the local circumstances, right? There are 2 components. One is a public-facing legal service. Public-facing means providing legal services on issues relating to people's livelihood, local governance, stability. The government-facing public service mainly inviting lawyers and legal scholars to provide legal advice to the party government committees. They are paid sort of full-time position, ad hoc. They hired from the legal market and from universities to help out with the government. A third example is the dispute resolution through contracting out, where law firms and the lawyers are invited to enter into agreements. According to those agreements, lawyers are tasked with resolving disputes in specific communities or providing mediation services annexed to labor arbitration commissions of the courts. The final example I'll give is the sort of duty lawyers, right, to be stationed in detention centers, which this institution has studied closely many years. One parallel important, which is very significant, was normally not regarded as part of the public legal service, is the expansion of public interest litigation controlled by the bureaucracy, right? So, for example, you may have seen China has expanded public interest litigation, but then they're mostly dominated by the state. According to the Supreme People's Procuratorate, for example, in 2023, they instituted over 95% of the public interest litigation in China, and they say they win almost every case in court, right? The implication would be that civil society organizations and lawyers who independently pursue public interest law will likely retreat further into the shadows. Finally, let me just spend some few minutes on the professional story, right? As a general rule, since 2019, a lawyer should provide legal aid as defined by the government in not less than 2 cases per year, or legal services of not less than 50 hours. Of course, there are significant local variations. The Chinese concept is both narrow and broad. Narrow in the sense that the government exclusively determines what counts as legal aid services. If the task is not on the list, if you are not invited by the government, it is not regarded as legal aid services in the sense of government procurement of services. But it is also very broad in the sense that ordinary legal services out of court is potentially limitless. In one province, for example, they include legal propaganda. By the way, propaganda is a positive term in the Chinese language that includes sort of provide legal services in around significant days such as March 8th, the Women's Day, March 15th, the Consumer Protection Day, December 11th, the Constitutional Day, and also you go to village, go to schools, go on to streets to offer legal services. The one important example is to persuade lawyers in the South and in the Eastern region to spend a year or two in the Western region. So it was very popular. There are lots of people going to Tibet for 1 year serving as legal aid lawyers, government legal advisors. That has become a highlight of the sort of public legal services. The question is why the lawyers are happy and rush to the government legal services. There are two reasons. One is because legal aid in China is paid. And in the past few years, the payment has become quite meaningful. Right? In southern China, for example, one particular city, you handle one case, you pay the 3,000 RMB. Not too bad. Right? Given the salary of so entry lawyers probably is about 8,000. So if you handle 3 cases, there's more than one month salary. So that is the incentive. Right? There are money there. Of course, the flip side is that China now has too many lawyers. Right? You may be surprised to learn that over 60% of the Chinese lawyers entered into a profession after 2017. Right. But basically, what's the meaning? The meaning is the Chinese legal profession may be collapsing on its own success, creating a generation of young, inexperienced, and grossly underpaid lawyers who are quite desperate. Responding to the call of the party to participate in legal aid services. But there's also a strong ideological dimension. The party has called on lawyers to participate, and it has become a political necessity to be part of the larger public legal services. But the expansion of legal aid, paid legal aid creates two problems. One, of course, is you're not quite sure how the decision is made, right? Not everybody is eligible. You need to apply, and then the process of determining who can be a legal aid lawyer is opaque, to say the least. Right? So that there will be lots of allegations if you are not picked, right? If you're not on the list, you would alert something wrong with the process. The more significant one, of course, is political censorship, right? So as the the legal aid laws said very expressly, the government admits legal aid lawyers according to their merits, both professional and political. Political reliability is a key requirement. Right? You cannot be a sort of the public government-facing lawyer giving advice to the party committees and the government unless you are regarded politically reliable, as one of the local regulations says. Communist Party members would be preferred. Right? So in conclusion, I would say that with the attractive payment in the range of legal aid schemes, political vetting of participating lawyers, and the management of legal aid through contracting and other accountability mechanisms, the government can control the framing of disputes and the direction of the legal process, ensuring effective and managed resolution of disputes so that the legal system would not produce shocks. Right? In that sense, pro bono serves as a political agenda. If that trend continues, there's the caveat, subject to the capacity of government to continue to pay the lawyers as they promised to do, the legal profession will soon be re-embedded in the States. Thank you for your attention. I'm sorry for taking up more time.
Well, clearly, this is a research project with a lot of layers in it. But the thing that I think will strike many people most strongly as an initial matter is that your entire thesis contradicts something that has been a popular notion outside of China in the way that scholars, and not just legal scholars, but scholars of China generally have told a story about what's happening now, which is to say that China under Xi Jinping has turned away from law, right? So the turn against law has been a framing that has been put around legal development of the past decade. And the story you're telling is not that. It's much more complicated than that. So that I just want to note that and invite you to comment on that. But also want to go back to the beginning of your story, which is in the 1990s. And you said that the 1996 law and litigation, lawyer's law freed the legal profession from being state workers, allowed them some autonomy. I just want to push back on that a little bit because it sounds, I mean, at the time in the 1990s, we didn't experience it as being a liberation, right? It didn't feel that free at the time. And lawyers at the time certainly were surveilled. They had to register with the local authorities. They have the annual license reviews and so on. So when you say that that this law created a more or less autonomous legal profession, are you overstating it a little bit?
Right. So the first question, I think, so in the past, say now 10, 15 years, China at the same time tend away from law, but also tend towards law, depends on the sort of policy areas. So that I would call sort of a dual state argument as you have very clear prerogative sphere where the party dominate, probably law tend to be more silent in those areas. In the area of national security, anti-corruption, I think the government or the party has significantly tend away from the sort of traditional rule-based governance. But then in other areas, sort of a private law issue, private law rights, you think about the Chinese civil code, significant, so people say it's masterpiece of Chinese legislation. Definitely China has tend towards law. So we see that's clear bifurcation. I think it really somehow you touch elephants. If you touch national security, there's basically lawless. But if you touch sort of torts, for example, you will see a wonderful legal system coming up. I think it probably just have to step back to look at the legal system more broadly. That's the answer. The second answer is yes. When the lawyer's law was passed, I think nobody was excited. It's only, I think, my view is only looking back 30 years, 40 years after you start to see the significance. But I think, remember, by that time, Xiaoyang was the minister. He was the person behind the legislation. He just kept saying like, there's no change, right? And the new law says guidance, right? 指导, right? The old law said leadership, right? He was trying to say, oh, it doesn't make any difference. The guidance is leadership, leadership is guidance. It's the same. You're still under government leadership. But as the profession evolved, then law firms start to have their autonomy. Yes, they have to renew their license. Yes, people like the practicing certificate was not renewed. But then for the vast majority of lawyers, it has become a routine. They never encounter difficulties. For them, it becomes tremendously autonomous. The issue for me is always is not the Chinese legal profession is not they're under tight control. There's too tight and too loose. Because if you look at the lawyers' regulation, you cannot really, it's not near what the American bar can do to their lawyers. So they control certain level, but then they don't really control at the most important level. I tend to argue they control in the areas they shouldn't be controlled, but they don't control in the areas they should have more significant and meaningful control. So
like quality
the
control.
quality control, ethics, for example, those are the issues. Okay, it's really so wild west. Until recently, lawyers are, in that sense, very free,
Yeah.
extremely free. Of course, if you talk about politics, which is what we have been looking at mostly, yes, it's tightly controlled. But that is sort of so again, you need to look at the profession in the whole sort of a spectrum to say what is tightly controlled, too tight, what is not controlled. So in that is, I still think that's evolution. If you trace that sort of a whole legal profession's significance, you have to go back to 1996. And that's why people are worried. Are we going back to the era before 1996? If every lawyer is now work for the government, paid for the government, listen to the government, then so de facto we are going back to the pre-1996 era. So that was my concern. That was the concern is developing gradually.
But what you're describing is not pre-1996. In fact, though, I mean, it's this very, it's a much harder to parse situation where you have both good and bad intermingled in a way that in any given situation, you could have a much better outcome. For example, someone who previously 10 years ago, 15 years ago would not have had access to a lawyer now may indeed have access to a lawyer, and that lawyer actually may have a law degree, which was not necessarily the case 20 years ago.
So that's why I said at the very beginning, it's always a good thing for the government to spend more money on legal aid.
Right.
But then you also need to be aware of the potential. What's the longer trend? What's the direction?
So how far would you push that? I mean, obviously, you can only see so far into the future, and nothing, very little that has happened under Xi Jinping has been exactly what we expected. But how far do you expect this to go? You're not, are you suggesting that the private firms will gradually be in some sense taken over, a little bit like the private tech companies that now have to give golden shares to the state-owned enterprises? Are private law firms going to have to give some kind of golden share in reality or metaphorically to the government and the party?
I think organizationally, probably law firm will mostly stay as private partnership. But then China has the first government law firm now, right? They set up a firm, right, to do public interest, the public legal services. It's just government firm. Well, you start one already. I think probably the good reason why you have a pilot, maybe the so piloting sort of a new scheme to have a sort of government hands-on management, right? So I saw the sort of advertisement for lawyers to government firm for the first time in the past since 1996. But I think that probably is a long shot. I think the main concern is the works the lawyers would do. I think the main concern is not the institutional identity. You're part of government. I think the main thing is in your work, when you're making sort of when you go to the court, when you frame the issues, the government would have a say. So the main thing that neighbor disputes is just a neighbor disputes. Forget about sort of unionizing, forget about strikes. That is a political, just let's say be a technical lawyers. If you're going to defend Falun Gong, don't talk about freedom of religion. Just talk about the criminal procedures, whether the police has forget to sign on the piece of pamphlets, well, then you could exclude that. So there are legality there, but then you have to sort of push back if you go beyond that particular.
So every case is just a single case, and no case is representative of a structural problem.
Issue.
So nothing, there's no strategic litigation in that way.
Right. So that is the sort of the beauty of legality. It individualizes sort of grievances, right? grievances is collective, but then the legal process individualize it, right? It's just atomized process. You appear as your own, as a single litigant. It's useful, right? If you are one of the person who are discriminated against, you would want to have a free lawyer to fight, and possibly you would win. But of course, if you step back, there's a larger issue. There's always a structure issue. So I think that is sort of the boundary, right? Issue. So in that sense, China is not turning away from legality, from law. But then there is a limit as to what sort of legality law can achieve in sort of social justice or redistributive justice, if I may use the term.
Right. So let me start taking questions. All right, go ahead.
Thank you, Hualing. Really, really interesting. And to follow up on Catherine's questions, at the local level, who polices these boundaries? To make sure, for example, that the young lawyers who are handling these cases don't go too far, that a labor dispute doesn't become something broader. Is it the firms that they're part of that are in effect delegated to discipline the boundaries, police the boundaries? Is it the agencies that provide the money for the contracting out? Is it the bureaus of justice at the local levels? Is it public security directly? Do we have a sense, and we may not, but do we have a sense as to sort of who steps in when lawyers who are supposed to be working on individual cases go a bit too far?
I think that there has been an evolution of responsibilities. If you go back, say, 15 years ago, it was predominantly security, right? They are watching. For some reason, when Zhang Jun became the minister, there was a shift from security to the Ministry for Justice. Right? They said it's your job, not our job, to discipline lawyers. So for a while, and until this moment, so the Bureau of Justice was very hands-on. That's why they started to disbar lawyers, because that's their power. Right? The security can only detain you; they cannot disbar you. Right? So you see, in the past 10 years, there's lots of cases, suspension. Right? Now, I think everybody wants to push the burden to someone else. So now they're pushing that to the Chinese Bar Association. The Bar Association is pushing to the law firms. Law firms pushing to the partners, right? So basically, you see the chain. So everyone is trying to ask the next the person on the food chain to do more, because it is a hard job, right? Those lawyers, if they do it, they are sort of have their personality. It's not easy to sort of bring in those sort of die-hard lawyers, for example.
Okay, let me take one from online, and then we'll come back. I'll start to make a cue here. So politicization aside, is there any empirical data on how satisfied claimants are with the results of the legal aid facilitated litigation? In other words, how well is this actually working out? And by the same token, is there any way of evaluating the extent to which the determination of the cases is in accordance with Chinese law, as opposed to mediation between the parties that's not necessarily constrained by legal rules? So is it following the law?
Right. So the second question, of course, is a hard one. So if you read some of the contract, right, between government and law firms, you take care of that village. And basically, I give you, say, 5,000 per year. Every dispute in that village is your responsibility. Their sort of requirement is basically stop disputing, don't go to the courts, settle it, internalize it. So I guess that requires some sort of field study. I think anthropologists would have a significant role to play in the process to say how that is done at the grassroots level. Right? I mean, of course, the mediation in China is always the sort of a formal requirement. It must be voluntary, it must be legal. So to what degree they are not voluntary, they are not legal, I think it's an empirical question that can be studied. The other question, I think, again, is about the results. I don't have any study. That the difficulty is, I think, relates to the quality of legal aid cases. That also worries government a lot because they're spending so much money and they're not quite sure, I mean, the quality of the service, but then it's just difficult to monitor legal aid because they are individual cases. They are invisible, largely invisible. They happen in a very formalistic process. It's very difficult for outsiders to monitor the insiders. So that is, so they have lots of forms, multiple, but then they tick the boxes.
Yeah. That actually brings up something that has always puzzled me a little about Chinese legal aid, which is that the government, the Ministry of Justice early on set up legal aid centers, right? And they're in every province, they're in many township levels and so on. But usually these are only staffed by non-lawyers, by administrators, and then they farm the cases out to the private lawyers who are in law firms. And that is what makes it hard to supervise them from a legal point of view, from a quality point of view.
Yes.
If you had lawyers who worked out of the legal aid centers, you could train them, for example, you could make sure that they were trained for this particular set of clients, because of course in a commercial law firm, maybe what they do most of the time is contracts. But then when they're called upon to do legal aid, now suddenly they're defending a criminal defendant, and they never do criminal defense, right? And they have no training for criminal defense, and then there's nobody supervising them in terms of the quality. Why do they continue with this farmed out model when it makes it harder to supervise?
I think if you look at the different Chinese cities, they have different models. In some cities, there are more sort of staff lawyers handle cases.
Okay.
In other cities, they are just administrators that farm out. I think that there will be a very interesting research topic for people to look at. So why they differ, whether it has to do with economy or the number of lawyers. I think they do have staff lawyers, but then increasingly they are farming out because they want to bring more lawyers on board, participating in the government public legal services. Probably partly they are dissatisfied with the staff lawyers, what they can do, given the huge demand and given what the government want to do to serve the people, to reach out to most of the cases, as sort of Xi Jinping said, is to send a sort of equity and justice to the heart of every litigant, right? And that is a very demanding task. Requires
very lofty goal.
Lofty goal. It really requires lots of lawyers to participate in the process.
Yes.
Hi, I'm Karina. I work at the Van Center for International Justice program out of the New York City Bar Association. And a lot of the work that we do is pro bono internationally. To your point, we actually have in-house lawyers that work on these pro bono cases to manage the quality control and make sure that the work that we're getting from the lawyers is in a memo that makes sense, or the information that's there makes sense. I have a question for you regarding the role of nonprofits in the country when it comes to pro bono. We work with clearinghouses, which are organizations that are usually funded by private law firms. And we kind of come across this issue of the country's legal aid and then clearinghouses. The governments in other places, like Spain, for example, that's the one that comes to the top of my head. They didn't want to mess with the already existing legal aid work. And when a clearinghouse came into the talks and conversations, they were like, well, you can only work with nonprofits to work on these cases and don't mess with the legal aid. I wanted to ask, what kind of role do you think nonprofits play with pro bono and lawyers?
Let me just briefly restate that first, because I think some people online are not going to be picking up the sound as well from the room since the mic is here. So basically you're saying your question, the bottom line question is, what role do nonprofits play in China in handling pro bono, but you're pointing out that in other contexts, there are multiple channels for getting plaintiffs who need representation to find a lawyer. There's not just one channel.
Yeah, we have here expert nonprofit in China, so he probably Mark will be able to answer this question better than I can do. So I think that two aspects. One is nonprofits, especially those from outside of China, is very difficult to enter into the Chinese market. The process is just difficult. I think it has deterred many from planning to go into the Chinese legal market in the near future. But then there are growing domestic nonprofits. The companies are getting richer. They start to have their own foundations and supporting sort of public interest litigation, for example. So they exist in parallel with the Chinese government-run system. The main worry is future space. I guess young lawyers are rational, right? They're thinking about it. So if I go to that area, what's the future? What will happen within 5 years, 10 years? If you cannot think clearly, you tend to probably make alternative choices. In the Chinese case, my understanding is you have the older generations, right? They used to do it, they continue to do it, right? Work independently of the government legal system, still passionate. They may have difficulties attracting younger generations to participate largely because the future is so uncertain.
Well, for many years, there were certain pathways, not very clearly marked, but pathways to sort of recruit young lawyers into public interest practice. One of them, for example, was law school clinics. And a lot of law schools had legal aid offices or services that the students themselves ran, right? I think this began actually around the time of the lawyer's law, right? I'm trying to remember what the first.
2010.
Well, in the 1990s, though, didn't Fudan University Law School have a very early model of a student-run legal services? And of course, Wuhan University very early also had a legal aid center. And those introduced the concept of public interest law as service, actually, to a new generation of lawyers. And although the impact was numerically small, it was powerful. How well is that channel still surviving and is still bringing up new young lawyers?
Well, the university law schools, legal aid centers continues to be popular. Many schools have sort of clinical courses as part of the graduation requirement. I think the significant changes is because of legislation, they are not allowed to appear in court as they used to be able to do. So if you take that thing out, as students participate because the imagination, being a lawyer in court, fighting for justice, that's creates lots of incentive. But once you say you can't do some legal advising behind the scene, some of this incentive sort of disappeared and the passion just dropped. And the larger political environment is also important, right? Students want to do things that is exciting, something new, something that is challenging. If the things is simply simulated cases or just ordinary, so we go to the arbitration center, set in, to make photocopies for the lawyers there, it's just no longer that interesting. Right. So and China tried very hard. I think Ford Foundation was a huge part of that. Right. Try to sort of transplant, if I may use the term, the U.S. Law schools, the students clinic system to China. By the end of the day, it is a decision the government made. You cannot appear in court. Right? So that is, I think that is like fatal in many ways. But of course, it is still there. I mean, every year there's a law school has this association of clinical legal education. They meet every year to talk about, it's the same problem they're facing. Who's going to teach, what to teach. It's very intensive, where the funding comes from. And by the way, I mean, everything is centrally organized because in the Chinese Ministry for Education has this requirement, right? The university must teach clinical courses, right? To get funding actually to universities. Of course, the funding probably will be relocated to other purposes because, everywhere is the same. It's research, nothing but research. Clinical education is always marginalized.
So let me take another question from online. Ira Belkin asks, the party's strategy toward the legal profession seems to have many parallels, including in Hong Kong. Xi Jinping told us that everything, including the legal system, must be under the leadership of the party. The legal profession can expand and flourish as long as it serves the interests of the party. My question is whether having all these lawyers in the system may serve the interests of the rule of law and justice, even if those concepts conflict with some party policy.
I would think it's useful. Actually, another day I was counting how many lawyers are party members, how many lawyers are sort of deputies in the Congress, how many lawyers are in the sort of within the government given advice. I think it's always, if you think about it, you could think about the terms of juridification, right? Sending lawyers to the party committee, it will have an impact because the lawyers, if they are real lawyers, think in a particular way. At the end of the day, that's your baseline, right? Nothing else but law. So I would be more than happy for the lawyers to join the party's sort of research institutes and those powerful institutions. Yes, it's China is under Communist Party's leadership, and nobody is denying that. And I don't think any sort of a sane lawyer would say I'm not under Communist Party leadership. But then leadership is a categorical concept. There are things under there. You have to do things. You have to draft a contract, right? You have to give people assistance. So there are rooms. I would probably say if you're a party member and has the trust of the party, then you have more rooms, have more space. And look at what Tony Hua has been doing in China. He was a party delegate, right? I mean, he could get funding. He participated in decision-making process, making real significant inputs in the drafting process. The other lawyers outside the system would never be able to get involved, right? So that's sort of a strength. Of course, there's a limit of the risk of capture. But then under that political system, everyone is captured to a different degrees. So I guess it's difficult, right? There's always the issue of insiders, outsiders. That they play different roles, have different functions. It's very difficult to say which one is more significant, right? Or insignificant in what sense?
Well, thank you for a very interesting discussion. I think in the US as lawyers, we're always puzzled a bit. If lawyers are told when they're representing clients that they must also consider other interests of the state of the party, or they're told they must limit their strategies and tactics because it's disturbing to society or the party. So Mark asked, how is it enforced after the fact? I'm curious, wouldn't it be even better if there were some sort of standards or some way to let lawyers know in advance what's permissible and what's not permissible? Are there any real efforts to do that?
I think lawyers would be socialized in knowing the boundaries. If you are in the industry for that many years, just a journalist, You don't need to be told how to self-censor yourself. You learn that that's your job, right? So I don't think that would really cause problem. The boundaries shifting, yes, but I guess, if you are in the profession, you would necessarily know. I mean, there are people try to push a little bit. As your opening statement, if you look at the code for judges, a code for lawyers, there's always the split, the loyalty, right? There's your party member under party leadership. Yes, there's the first order loyalty, and then you are judges. Think about how best you can be a judge within that framework. There's a limit, a significant limit, but then I think there are still space for lawyers. Otherwise, then what the judges will do. I think it's not an answer to say, well, there's a party leadership, nothing would happen. So yes, under the leadership, there are lots of things could happen. Just look at China in the past, since 1949, it's always under the Communist Party leadership. That's never changed. And look at how different the society has been in different stages.
We also talk about socialization of judges in Japan. And a lot of that occurs during the educational process. Is that true, or professional education and professional training?
I think, unfortunately, Chinese education probably is not that, what's the term to use, down to earth. It's more like academic. So Chinese law school has never become a professional school in the true sense. So you don't associate, you cannot get the necessary socialization in a law school setting. You have to go out to realize, wow, I wasted 4 years in law school.
Well, in any system, norms can be just as powerful as law or nearly as powerful. So it sounds as if what you're saying is that the party directives and the policies of the day, they form another carapace around, in addition to the actual carapace of law, and everybody can see it. I guess the question would be, how reliable is it? You can believe that, well, last year I handled a certain case and it went well. And so this year I'll take another case like that. Maybe, for example, property seizure. Very common kind of public interest case, one of the most common subjects of disputes in recent years with the high pace of economic development, urban redevelopment, and so on. You might have handled a property seizure case last year with no problems, maybe even got an award for it. And this year you find out that actually it is sensitive because, unbeknownst to you, the mayor has an interest in the property under development, or there's been a shift in policy and you missed the memo. Then suddenly this set of norms and other guidelines in addition to law that all societies have becomes a little bit less benign.
Right. So I think the quick answer is, it's important to look at the vast majority of the cases for the vast majority of the people. There's always the outliers in the Chinese system, right? I don't think we're talking about sort of the rule of law in that sense. We are the cases you are referring to, probably we call it, those are exceptional cases, sensitive cases. Of course, what makes the study of Chinese law interesting is it's just hard to figure out what actually separates, say, 95% from 5%. Right? I think the party may have said, you have the autonomy for 95%, but I have the 5%. Cases I decide, but I don't tell you which 5% I have to have. That is the system. There is uncertainty, but then there is the certainty, right? So I guess is if you are your eyes is on sort of the ordinary transaction, the private law enforcement, I think people would still see legal certainty. So maybe it would be nice research topic, right? Ask lawyers when you look at it. So when someone walk into the office, what's the answer you can give you? Right? Are you going to say, I have no idea because Chinese law is so uncertain? I think most of the lawyers in most of the time would say, go back home, it's a waste of your money, right? Because that is very clear. I think Chinese laws in the past 40 years has developed enough sophistication. It's very thick in the rules, the norms. It's coming to sort of a hierarchy. I think if you're a good lawyer, you would have a good understanding of what might come out. So basically, there is a consensus. I mean, but that goes by law school education is important. When I say it's not a professional school, I don't think I'm not saying that they haven't learned any law. I think if you put judges, lawyers together, have a conversation on property rights, I think they would know where they disagree and why they disagree. So there is sort of China is developing sort of a self-referencing sort of a legal system on some of the issues. Yes, there is a sort of political intrusion into the legal process, but then I think it doesn't mean there's no legal reasoning and legal thinking, especially in contract torts, property. I think it's getting quite sophisticated, I would say.
Yes, thank you. Just to introduce myself, because I'm usually not part here of NYU. My name is Nina Reiners. I'm professor of human rights at the University of Oslo's Faculty of Law in Norway. And I have started last month a big 5-year research project on pro bono by the big private law firms as transnational advocacy. And it's fascinating and very interesting. Thank you for sending me your paper also, because I'm interested if this pro bono by private law firms could be a potential solution to the problem we see that we have this shrinking civic space around the globe, not really human rights defenders, environmental defenders cannot really do their job anymore. So maybe here we have a potential solution. And so my first question would be if you could say a bit more about who these lawyers are doing pro bono in China. So I assume I get the point that they are paid, that this is very attractive, but does that apply to all attorneys from all firms? Because I would assume like the very big one, what's the name, Yinki and so on, maybe not so attractive for them. And then I have some questions on the agency. So if there is this political control and that becomes quite apparent in the work of the lawyers, how do they deal with it? Is there something like that you observe at the individual attorney level? Is there a broader movement also among the lawyers to exchange about that? We already talked about the role of the bar associations. And a very broad question, but do you see under which conditions, could you tell us a bit about the conditions under which it is possible to mobilize maybe as lawyers in China for change, so to make progress? I was very fascinated by by laying out the role of local governments, for example, that can be more supportive than others. But also when it comes to environmental cases, I assume there is maybe more interest at some individual attorneys level to use that to advance the law and the protection. And I would be very interested if you can share your insights into under which conditions such actions could be effective.
Oh, the last question first. I don't imagine lawyers can really get organized outside of the official structure, right? So they organize themselves through social media very effectively, forming their own sort of pockets of free thinking, or if not resistance. No, resistance is not the right term to use here. I think it's issue-driven. Say, for example, environmental protection. There are lots of space, even for lawyers outside of the government system to advocate, right? Because the environment is what the government is pushing And that's what our president wanted to sort of develop. So you have sort of the baseline legitimacy. The only difference is whether the measures, right, the way you do it is can be tolerated. So I think as the wind shifts, I don't know, next year maybe something else is maybe say food safety, right? And then the lawyers can be mobilized to do that. I think that is so you have to wait for a political space and some political opportunities for lawyers to get sort of mobilized to be sort of politically viable. So that is number one. On your first issue, big law in China, I think they also, because they're big and they have their own in-house sort of pro bono. How significant it is, I don't really have a clear answer. My sense is probably is quite marginal because they also participate in the government-run public legal service platform. Because as I said, it's not just mere for money. And partners, you have to demonstrate you are part of that system, which the government is promoting, is serving the people, is promoting rule of law, right? Solving social problem. Partners in particular, you have to be seen. You are there on streets on that particular day when government called, be there. So you will be there, right? I mean, the money, yes, will be relevant for some, probably is not relevant for others.
Mark, yeah.
I want to make sure others who haven't asked, go ahead.
Thank you for sharing your research. I'm really curious about this policy known as government procurement of service. 政府购买服务. And last time I checked the policy was around 2020, 2021. And I believe the Ministry of Justice and Ministry of Finance issued an opinion in 2020 to articulate this idea that local governments could use their revenue to purchase services, including legal services from both lawyers and basic level legal workers, right? And that was 2020. China was just about to enter COVID. And since then, Chinese economy has continued to struggle. So I'm curious to what extent, local governments can really set aside money for their procurement of legal services, right? And back then, around 2020, 2001, I honestly couldn't find any statistics on this front. So I knew the policy was on books, but I didn't really have much data on the actual implementation of the policy. And now it's 2025. I'm curious if you have seen any statistics about the implementation of the policy.
The Shenzhen Bar Association released the statistics for 2023, the total negotiated cases involved and the numbers of lawyers participated. It's quite interesting in the sense that it's like there are quite a few thousand of cases legally aided, but the number of participating lawyers were quite limited, which means a small group of lawyers sharing the pie. But the money-wise is still quite big. I guess probably it's because of Shenzhen they have different. But my understanding is, yes, it is a concern. I heard from lawyers sometimes they're getting like an IOU note now. And I think some government used to pay a lot. Now I think can reduce the fee per case. So yes, I think that trend, as I said, is subject to the funding capacity. It will reduce, but then the design is such. My worry is at which point, right, the legal aid money is no longer meaningful. Lawyers that say, no, I'm not going to be part of it, right? So that will be the tipping point. I don't so far, because the impact is on everything, every lawyer. If you are a young lawyer in a city struggling, I guess 3,000, 2,000, 1,000 doesn't really make any difference. You just want to have some income. So that probably the incentive will continue to be there. I think that platform has been built in a way it's quite efficient and effective in the Chinese setting. And as long as there's narrative of a rule-based governance, socialist rule of law continues to be sort of promoted and developed, that there will be, I think it will continue. I think in many ways it's tied to the more recent Feng Chaojin source governance, right? You need lawyers to go down to the level of community to track individual cases, and if there are financial incentives, I think probably is maybe sort of the Chinese system is well known for sort of a preventive justice, I put that way, right? It's not sort of a remedial justice. So if you want to prevent sort of disputes at the earliest possible stage, so of course you need a monitor, you need a deep level engagement, you need to send down lawyers to the community. So that's what they're doing. So in that sense, it will continue, but also evolve. And I think it will mutate in many ways. But then the baseline of my argument is will be a government controlled system, right? You are serving the interest of those people, but then under the macro sort of a political design. So that is the core argument I want to make.
When you mention preventative measures, that makes me think of the recent cases of violence, random violence against people in public. So for example, last fall, there were a number of cases in a row where a man who apparently had a private grievance drove his car into pedestrians, people who were exercising outside of a sporting complex. And then there was another case of a man taking a knife and stabbing people on a sidewalk outside of school and so on. There've been a series of these. There were quite a few in the fall. And apparently we hear that after this happened in the fall, Xi Jinping himself issued instructions that local authorities were supposed to identify anyone in the community who might be unstable enough or unhappy enough to do something as crazy as, attacking random strangers in public. Did you hear anything at that time that lawyers were given any specific role in that preventative initiative?
I think it's part of it. I think the strength of the Chinese governance is in the community, right?
Yeah.
You don't really have design as the Chinese gated community anywhere else. So probably it's something that is very powerful, right? Rooted in the community. Of course, the murder, they're contagious. You watch TV, there will be a copycat next time. So that's why that part explains Chinese censorship. Don't report on bad things because people will learn from that. So can be that actually it has to do with court trials. The cases, this one, I think both cases, they're grave because they are not happy with the court decision. Right, they appealed and then they didn't get what they wanted. One is divorce, I think. So the issue is, what's the challenge for the judiciary, right? You make a decision, it's not, yes, legally binding, but not socially binding. People don't listen to you. Then what's the solution? The solution is there are multiple. One is forget about court, you're not that important, right? Another way is you need to empower the court so that you make a decision, people will really follow. Maybe that is the solution. So I don't think on those cases, I don't think the party made a clear decision. I think that the only thing they think is, okay, watch out those dangerous people. But that's nothing new in China. In Chinese community, there's always this concept, the dangerous people in the community, right? The ones who violate one-child policy, right? The Falun Gong practitioner, now people are psychologically sort of distorted. The way that it could happen is because Chinese has this social structure. You have the gated community and you have the resources of institutions and you have a culture. People would not be surprised if someone knock on your door and say, I want to have a conversation with you, because that is what it is, right?
Mark?
decades or eras, we've seen policy experimentation possible with permission in certain parts of China, in the civil society area, Kunming, Shenzhen. Policy experimentation, the broadening of boundaries possible with permission in any localities under this government controlled. Secondly, how is this new system on the mainland affecting the discussions about pro bono legal aid in Hong Kong, if at all?
Nothing happens in Hong Kong. We are still one country to system. So politically, yes, it has the impact at the legal, social level. It's just not relevant. People in Hong Kong have no idea what's happening in the mainland and vice versa. So we're not interested in each other that much. So that's one. Yes, the first question is interesting. I think the patchwork in China in the past 10 years is Ding Chen Seji, right? The designing at the how to translate that? I also have
Top level
top
design.
level design. So it sent a signal: don't mess around. It's not for you to design. So I don't think that there's clear instruction not to do pilot, but it simply just feel like, okay, Ding Chen Seji will just okay, tell us what to do, we'll do it. But necessarily you would have local sort of pilots, because it's just different. Central government just gave you, say, do sort of public legal service. How much money, right? Who gets involved? What's the accountability? Then you just have to design city level, provincial level. So given the nature of China, necessarily is fragmented, demand sort of local initiatives. You don't say that, but then you do it.
Well, that is a nice segue into a question from Margaret Wu. What, if any, are the variations between provinces? Poorer rural communities, are poorer rural communities more controlled than economically advanced provinces, or is it possibly the reverse, that the economically advanced provinces are more controlled than the rural provinces? Is there anything to support the argument that economic development supports greater independent use of law?
Well, independent use of law is not really a concept that we think about in the larger political system. But then I think in the cities, lawyer will be probably I shouldn't use the term control, it will be managed by the state, right? Because they have more money, they have more lawyer. If you go to the countryside, you don't really have that many lawyers, right? And free legal services probably is an alien concept at the rural area. So yes, there are great variation. The limit of this draft paper is really I look at the cities. I haven't really get a chance to look at sort of the county level, for example. My understanding, it doesn't matter what you say about that. There's only that much you can be done at the county level, right?
Well, in the rural areas, there have always been this unique institution of the legal workers,
Yes.
right? So maybe what's happening with them, and with these are people who are employed by the township government, for example, and they are not necessarily formally trained or have very minimal formal training, but they are employed by the government to provide some basic sort of legal information and guidance to people in rural areas. I know Professor Lee has written about them, and maybe she has something to comment here on that, but for many years we heard that they would be ended because, now we have so many actual, trained lawyers, and they never have really been ended, which seems to indicate that the government sees the need, because as you said, there aren't actual lawyers in the countryside. How did they fit into this scheme? Are they in a way the prototypical example of the public legal services of this conception?
So there are two types of people in the sort of countryside. The legal workers, they are not paid by the government. They are just like law firms in the countryside. You have to make your money. Actually, you have to pay the government for the registration, right? That has always been a big issue for them. What you're referring to is the sort of司法所, sort of a justice station. They are paid for, but then their capacity is always limited, right? You have a couple of people doing all sorts of things for the whole town is wide enough jurisdiction. Yes, they are part of it. They look at the official documents, they are included, right, in public legal services. They're supposed to do exactly what the lawyers are supposed to do. So there's no distinction between lawyers and legal workers. But again, I think the issue is support, right? Because you need money. You go down to the county level, township level, the availability of lawyers will be, the fund will be more limited. So what I could say is, where action may take place is the sort of districts, the counties near the big cities. Then you could say something. I think that demands cost for sort of a further research in that area, which is new. I haven't say that much sort of writings in China on that very
And the state of rural
the
legal
state role
services.
of public legal service procurement, the qualities, right, evaluations.
Did I see him? So I want to then talk a little bit about the criminal representation, the criminal representation of criminal defendants, because you mentioned briefly the duty lawyer system, which was the big innovation in the area of criminal defense, that lawyers should be meeting with detainees who were being held in detention centers, who were presumptively moving toward trial, to meet and explain their option of agreeing that of accepting their guilt. What we would call pleading guilty, although it's not an exact analogy. And in return for that, they might get a sentencing discount. And so these duty lawyers' task, as it was originally set out, was to be the representative of the government, of the procuratorate, basically, who would explain this to the defendant or to the accused, that they had this option, and even potentially persuade them that this was a good deal and they should take it. In the first year or two of this system, we were hearing things like, that this was kind of like a factory assembly line type operation. You might go to a detention center and meet with dozens of people in the day, and then you were basically acting like a notary public, just taking a lot of signatures and certainly not offering representation, not having the time to go into the merits of an individual case. How does that fit into this larger system, and how has it evolved?
Right. I haven't looked at the duty lawyer very closely. I think when duty lawyers started, there was no sort of plea bargaining in China. So in that sense, duty lawyers were quite important, because the duty lawyer were the only one can talk to the family, talk to the detainees. So I remember there were some studies which showed that whether you have a lawyer, duty lawyer, or not, in criminal cases, had nothing to do with the consequences of the sentence, the verdict. But then it has a lot to do with the way you are treated in the detention center. Having a duty lawyer there would sort of prevent some sort of mistreatment, because there's a lawyer for you. So that in that sense, that was an old system. But then I think mostly after 2018, they really roll out the plea system, right? And then all of a sudden said, okay, duty lawyers will be useful, because you have a lawyer there to sign. As you said, they are just tick the boxes. You have a lawyer sign. To what degree they can really give some legal advice, and also arguing with the prosecutor,
Mm.
right? That is what bargaining, can you really bargain? I think the key issue is to bargain, you must have a position. You have nothing to bargain. Bargain means you have position, right? You're not in, so you say you're not in a position to bargain with me. So probably that exactly is, the duty lawyers is not in a position to bargain with the prosecutors. If that's the case, then it's bad. Sort of bad.
It's about efficiency.
It's about efficiency for what? That is, so yes, for the sort of prosecution. I think the key thing is not on the duty lawyers, the key thing is on the courts. At the end of the day, the case will have to go to the court, the judges will have to do something and say something, right? Whether the defense is meaningful, is effective, that has to be pushed back. I think the door to push is not the prosecutor. The prosecutor, of course, they have the self-interest, right? That's their power. I think a lawyer needs support. The support has to come from the judges, right? You have to be. I think that's still, judges are still trying to figure out how to respond to that, because all of a sudden their power disappeared, because once they have a bargain, the judges cannot do that much. They're not quite sure. I think they're still in the process of figuring out a response to that. The irony is the person who designed the system is the chief judge in China now, right? Right. So it's the same person who said left hand, right hand. I designed the system to limit the judiciary. Now I'm the head of judiciary. How I'm going to respond to what I did vehemently. So I think you need some time to figure that balance. I think in the Chinese system, individual is very important. How the judiciary is going to respond really, it depends on largely what he says. He knows everything. He knows better than anybody. So we'll see what he's going to say about that.
It does seem to have had some effects overall on sentencing patterns and things like that. Is that clearly?
You don't need criminal trial. So trial in China is disappearing very quickly. Right? So I don't know. I mean, probably the Chinese wonderland in the future is that there's no criminal trial. There's no crime. I mean, China probably is disappearing crime because of the system. I mean, I don't know. I mean, the good, not good. Sort of, we need to look into it more closely. So like you need the empirical evidence, you need the data to support whatever argument we may be making. The difficulty now, of course, is data is in a way is abundant supply, because we data for everything, but then at the same time we don't have any data. So.
Yeah, we need to know who's doing the duty lawyer role chiefly. I mean, according to some, it's mainly the junior lawyers, who don't know very much, and how much time they're spending with each client, and then what was there a sentencing discount or not, etc. I mean, so many questions we have about that. You raised the matter of the party cells in law firms before, I guess. And I'm just realizing this is probably the last question we have time for. You talked about the parties establishing cells in all of the law firms and recruiting more lawyers to be party members. Do you have any sense of what impact that has or has not had on the management of law firms to have party cells? Are they getting actively involved? It's a little bit like the question about the role of the party committees in the private sector, which has also been a new phenomenon.
Yeah.
Is there a sense that they're getting involved in substantive decisions, or?
I think probably you will have invite my colleague and you start to talk about that topic. He's doing research on law firms.
Okay.
My take probably will be whatever impact it has had, it will be the sort of a cultural shift. It's not really in the concrete decisions, because of what lawyer does is just day in, day out transaction, right? There's not much. This is the political ideology could make a significant impact. It is really the way you think about things, the way you hire lawyers, the way to hire a lawyer. If someone give you a phone call, one of the lawyers is doing something that is a bit controversial, how I'm going to respond to that.
Mhm.
So I think on that front, the institutional cultural front, it will shift Chinese law firms to a different direction, right? But then in terms of the concrete, sort of the legal work, I doubt it will have a sort of huge impact on the actual sort of handling of cases.
Okay, well, we'll leave it there. Thank you so much. This has been a fantastic discussion. Thank you all for participating.